Thanks for attending today. We appreciate it. We've, over the years, developed a variety of structuring and asset protection tools, both domestically and abroad. And in this seminar, we present a 50-minute overview of many of the options we found are very effective and how they interrelate. We're going to go through in the agenda here, we're going to go through both an introduction to asset protection. What are the scenarios we look at? What are your general tools for asset protection? Then we'll get into some detail on LLCs, how they operate, what the weaknesses are, etc. The same for trusts. There's a variety of trusts we use for different scenarios. And then we have a lot of CPAs on the line. We're going to talk about at least for 10 minutes or so, maybe 15 minutes, how we use the structuring on the estate and gift tax side. We'll also talk somewhat about avoiding income tax, but essentially blending estate and gift planning with asset protection planning at Section 4. So first, we'll do a general overview of how asset protection works with respect to which global options we have, which tools we would implement under a given circumstance. As you'll see as we work through the slides, different people have very different circumstances, so you really have to know which tools to implement and when. Asset protection in general, this is just an overview. We're not running away from anything. We're not hiding assets. The law doesn't really allow for that. Even there was a period of time actually when you could run away. Maybe you had a good faith argument in hiding, absconding, this kind of thing. We never got into it. It really kind of went badly anyway over the last decade for those who tried. We don't get into that. We really deal with people who are trying to plan on a sunny day, and we have never to this day had any of our plans, probably nearing 1,000 plans, been breached, not one. We do have people who are in trouble who come to visit us, who want an idea of where they stand. We can do that as well. That's an asset protection analysis. That is not planning. When we look at asset protection, we tend to focus on 4 tools. This slide works through them in the bullet points: titling, exemptions, trusts, and business entities. And when we choose a jurisdiction or we choose a particular tool, each tool has advantages and disadvantages depending on which one we choose. For instance, titling. In Florida, we're allowed to title both personal assets, which is non-real estate, essentially, personal, tangible, and intangible assets, and real estate by the entireties. Entireties comes from the 15th century England means of titling assets in both the name of the husband and the wife. It's a legal fiction where you join title together, and creates some protection under a lot of scenarios, really, where there's a weakness. We can sometimes fill a weakness with a tenancy by the entirety title. Now, assets in another state, if they don't have tenancy by the entirety, either for real estate or for personal property, you can't use it. So sometimes we pick which jurisdiction we'd like to use based on title. It's a little bit simplistic with TBE. In other words, it doesn't require a huge amount of thought, really, but it can be significant. For instance, if someone is taking title to a business entity, and for whatever reason we can't protect that entity, sometimes we'll move it into husband and wife titling, and that will somewhat protect it. The husband and wife titling isn't an ultimate asset protection tool. In other words, if both husband and wife are liable for the claim, then the husband and wife titling really doesn't add any protection. So it does have its drawbacks, but it's just a tool. And so when we choose among the jurisdictions and we're looking to place assets in within an entity or located in a certain jurisdiction, do they allow tenancy by the entirety titling in that jurisdiction, both for personal property and real estate? Many Midwestern states allow for real estate, but not personal property. And some of those states also have community property, which is the flip side, which means that the other spouse is actually liable for things that are attributed to their spouse, which we want to avoid entirely. Anyway, that's titling. So that's one aspect. We have exempt assets like life insurance, annuities, the homestead. And these exemptions are statutory. They vary from state to state and country to country. It's a little harder to manipulate exemptions because exemptions typically are derived from, at least in this country, are derived from your residence. So if you're a resident of Florida, you get the life insurance exemption, which is limited also. It's not an absolute exemption, the life insurance exemption. It's just of the liabilities of the insured, not necessarily the owner. So we pick and choose. With respect to exemptions, you may want to pick your residence, which happens all the time in Florida with the homestead. People pick Florida as a residence so they can bury money in their homestead, which is one of the wildest. It's a totally separate seminar. It's so involved, but it's one of the wildest things in asset protection even in the academic world, where you can actually be running from a creditor and pour money into a Florida homestead, and it's not available if you move to Florida. And then you have the contrast of trusts and entities, which have really moved to LLCs. Trusts it's an arrangement coming from the 15th century where we move money into the legal title of a trusted friend, relative, or advisor who is the trustee. The trustee actually owns, for legal purposes, the asset. And then that asset is held for the benefit of a loved one, usually. The loved one has, if the trust is properly written, the loved one has no access to the asset. The trustee has no access to using the asset unless at all. The trustees usually paid a fee, but the beneficiary has access only if the trustee allows. That's what creates the trust fund baby. That's why when we talk about LLCs, or valuable assets, clients ask, well, should I put it in trust? My son's 36. Well, you still may want to put it in trust. If we put it in trust and your son gets a divorce, or your daughter, it doesn't make any difference. That trust is protected. That trustee does not have to distribute. Those assets are not going to be tampered with. There are some wild exceptions, but it's very protective. And that's the trust fund baby issue. Is that the right thing to do? Well, it's the law. So if you put assets in trust for a child or loved one, and the trustee has control over distributions, that trustee does not have to make those distributions. So you've divided title, which is very powerful. The limited liability company is essentially a business entity, which is much stronger than the corporation, as we'll get into the details later, but it's not a trust. You're attacking someone that owns equity, and that equity is owned directly, and it's an asset, and it's available to be liened at a minimum. So it's not as protective as a trust. So sometimes we actually put the trust on top of the LLC, and we'll get into some of that as well. When we choose these jurisdictions with the LLC, this is an example where we say, okay, when we choose, okay, we're going to use a Delaware LLC, or we're going to use a Nevada LLC, or we're going to use Alaska, or whatever we're going to use, or Offshore LLC, and Nevis LLC, or Cook Islands. With respect to the U.S. states, did they use, for instance, the Uniform Act? So there's a Uniform Commission which proposes these acts, and originally the Uniform LLC Act, which is basically can be adopted by these various state legislatures, is pretty weak. So typically, if they utilize the act, they adopted the act or something like the act, we'd stay away from that LLC. That's just kind of some insight into how we choose which LLC to use. Here we have, can it be foreclosed, right? Can we use it? Can we title it in TBE, for instance, like we had mentioned? Well, it depends on the state. A lot of how we choose comes down to, okay, if we are in Florida, or we are in California, or New York, or Georgia, now we're doing some work in Georgia. If we're in Georgia, how does Georgia feel about us using a Delaware LLC? What have the courts said about that? In many states, we have a statute. In some states, it's just common law, case law, with respect to the internal affairs doctrine. The internal affairs doctrine says, even though someone may utilize a Delaware LLC in Florida, the Delaware court will respect the internal affairs of the Delaware law. Unfortunately, it doesn't say you have to respect LLC law, you have to respect trust law. It's this general doctrine. So it's not as specific as it really, in my opinion, it needs to be. But the idea is that you can use any state you want, you can use any country you want, and the court in the state where you live should say, oh, that law was established legally by that state, and we're going to respect the internal protections associated with that state. That's happened sometimes, and it's really been ignored other times. When we go through this choice of law, when we're trying to decide on what we're going to do, sometimes with respect to this first case, the Wells Fargo case, we figure out what the court's going to do with a bad actor. So we had said we don't do planning with respect to people running away. Some people do. So this woman, Sabrina Barber, was defaulting all kinds of real estate debt with Wells Fargo, started throwing cash into Delaware and into Nevis, West Indies. You can't really do that. That's a fraudulent transfer, which means that the court can go ahead and unwind those transfers, can find the recipient and get the money back. The courts oftentimes don't actually understand the whole process. In this case, the court actually said, well, you've got a Nevis LLC. We're gonna just call it a Florida LLC, and because it's a single member, we're just gonna disregard it and take all your money. So, and this is my opinion. I think that case could have been pretty easily resolved through fraudulent transfer, where the court had access. This woman left the money, the assets, in Florida. The court had access. It was a fraudulent transfer. They probably should have just taken it back. Instead, they went through this idea that it's a bankruptcy idea, that we can kind of make that entity the similar entity in Florida. We can kind of convert it ourselves and then call it a Florida, and then because Florida doesn't protect it, we'll take the asset. That's how far courts will go on these bad actors. So if you're a bad actor, none of this stuff's really going to work. If you don't have problems when you create the Nevis LLC and you properly structure it, it's very protective. I can tell you, it's very protective. That's kind of when we choose, we're really not choosing from a position of running away from a creditor. In the JP Morgan case, for instance, we learned that when we choose a jurisdiction, we under any circumstances, if we choose a Colorado LLC, which was the case here, they had litigation in Arizona. There was a collection action against the Colorado LLC. They made the mistake of suing in Colorado. So if you're a plaintiff, you don't want to be suing in the state where they form the LLC or the trust, because the court there, that's the key to the idea. The court there is most likely going to upheld their statute. Colorado was pretty protective. They said, look, it's protective. You can't get the money inside the LLC. Because the plaintiff went to the jurisdiction of the LLC, and we can give you I think we have a couple more examples that are pretty, Arroyos was a great example of that. So they had litigation in the state of Maine. Plaintiff won the litigation. There was an LLC in Delaware, but there was a connection to assets in Maine, in Alabama. So the case was in Maine, there was a judgment there, Delaware LLC, then they try to collect in Alabama. And it's very, very debtor friendly, this case, because the court says, this is an LLC that's formed outside my jurisdiction. I don't really want to get into it. You need to go to Delaware to collect on this LLC. Is that right? I don't know why that's right. I don't know exactly how they came to that conclusion, but wow, is that debtor friendly? That would mean if that case becomes precedent in other states, that if you create the Delaware LLC or use a protective Nevada LLC, you have to go to that state to collect. And that state, remember, where the LLC is formed, where the court is. If you go to a court in that state, that court is very likely to uphold the protections associated with that LLC. If you're a plaintiff, you want to get it heard in another state, and that may be why they went to Alabama, because the judge in the other state may do a barber on you and say, you know what, we're just going to throw this out. We're just going to collect it. This is not going to work. It's not in our state. We're going to apply our state law, and our state law doesn't protect you. This is what we go through when we kind of make these decisions, and I think we're going to soon see the California debacle and why we kind of stay away from California. This is a slide with respect to, which is correct. I really don't think, I think there's criticism on both. I think one went crazy with respect to the creditor. The other one went kind of crazy with respect to the debtor. In any case, I think if you plan it, if you plan right, if you're in New York and you use Delaware, you're in Florida and use Nevada before there's any problems, I think there's a very good likelihood that the court is going to implement the protections of the particular state LLC. That is outside of problems, and that's outside of bankruptcy. Well, I was going to note on bankruptcy, but we'll hit that in a few slides. So here's some nuts and bolts with respect to LLCs. We get into the general side of LLC law. It's corporate law. One of the advantages our firm has with respect to the asset protection and the tax planning is that I only did corporate law for the first 8 to 10 years, and then I got into this asset protection and tax planning. So you have to really understand when you do these plans the corporate side. And LLCs are corporate. A corporation has inside asset protection. If something happens in the corporation in general, if there's no fraud or anything else, alter ego, you're just using it as a piggy bank. If you don't have any of these problems, what happens in the corporation stays in the corporation. You're not personally liable. That's inside asset protection. So the corporation has that, and the LLC has that. What happens in the business is not going to affect the owners. It's just the assets of the business are exposed. That's it. Outside asset protection is if someone sues an owner, can they get their stock? With a corporation, the corporation totally, the corporate stock, the equity is totally exposed. There is no protection. With an LLC, the idea is that you can sue the owner, but you can only get a charging lien. You can only lien the equity. That's why an LLC is more protective than a corporation. When should you use a corporation? Pretty much never. There's some, we do some corporations with respect to startups that think they're going to go public. It's just much easier to go public, but that's kind of it. That's kind of it. This goes into why LLCs have kind of developed this charging order protection in their statutes. It comes from the partnerships. Partnerships used to have this charging order limitation on claims against partners because it wasn't fair that one partner had to deal with the litigation of the other. So if the other one was in litigation, the plaintiff can't get through to the business. That's how the protection arose. It's only significant with respect to understanding the single member LLC issue. This is some of the advantages of LLCs. It's much easier entity to deal with and customize. With the single member LLC, the protections were the same. In other words, when they first started drafting these statutes, you had a single member LLC. It was just like a multi-member LLC. If you sued somebody, all you could get was a lien. You couldn't get the stock. You couldn't get into the business. But bankruptcy got involved. So when you go bankrupt, it's a completely different process, a much more powerful court. What happens is the court wants to impose public policy on people who go bankrupt because in bankruptcy, you get a discharge of your indebtedness. So the courts kind of has leeway. Hey, you decided to go bankrupt. We're going to discharge your indebtedness. We want the assets. The law says that those assets are protected by state protections, but the court really wants the assets. So in this Albright case, which was an LLC case, it was a movie star who went bankrupt. They said, well, if you don't have a partner, that idea of charging order shouldn't apply. You don't get the charging order. You just lose your stock. It doesn't say anything like that in the statutes. These LLC statutes just adopted the protection and it was in the statute, but the court wanted the assets in the LLC and came up with this idea that the single member is exposed. That spilled over to Florida. There was a whole series of events. So that we had this Olmstead case, which pretty much eviscerated the protections of LLCs. The lobbyists got at it. The legislature came back, said, no. Multi-member LLCs are protected, but the single member LLC is not in Florida. It's a little more complicated than that, but essentially the multi-member is protected. The single member LLC is not, especially the investment LLC that doesn't make consistent distributions. So we've got this issue now where we never want to form a single member LLC really in any state because we really don't know what the courts are going to do. We have one case, as far as I know, we have one case with this Corchi case. So we're always asking, well, what's a multi-member LLC? What is a multi-member LLC? I'm going to make sure I get the time right here. We want to avoid it. We've been adding trust for kids. We've been adding other partners. We've been doing everything we can to avoid this single member LLC. In California, we had a mild bad actor. So we had a very wealthy guy, Baldwin, formed kind of an Andromeda strain family entity. And instead of kind of doing the tenancy by the entirety thing on his holding company with his wife and trusts. Now in California, they don't, it's questionable whether you can do that, but it was a Delaware entity. I think they at least should have tried to do it. Anyway, he defaulted, kind of said, nah, any boo-boo, you can't get to any of my assets. Default was only $5 million. This guy was worth a fortune and had distributed, not held in this entity structure, distributed $178 million over the prior 6 years, and just said, you know what, we're not going to distribute now because if we distribute, I have to give it to this judgment holder who I don't want to pay. And so the court was in a quandary, like, how do I get in to these assets? Because number one, there's a general rule on charging order, and number two, we have a case in California that says you can't do it. But the case was regarding corporations, and corporate stock is totally exposed. And so they distinguished it. And I think having read that case, it is distinguishable. They said that that this idea of breaking through to get to the assets of the corporation is not really applicable. And it's not, because you can just take the stock and then you own the stock and get to whatever assets you want. So the court's looking at, okay, how do I break into this 99.1%, 99 Baldwin, 1% the wife? There were some trusts involved, but basically it was like an alter ego. It was just him. He controlled everything. He made all the rules. He was the manager. There was just no aspect of it that showed it to be a multi-member LLC. So the court remanded and said, you can take this and try this again on this issue. We think you can call this a single member LLC because it's really just him. So you got to be very careful with this. So we do have a case, and it does suggest if you're egregious, you'll be broken as a single member LLC. Other courts have totally rejected it. There was a court, this was actually a bankruptcy court. Some of these courts actually do go back to state law and read it and say it's not exposed. So, you can't get to it. The more straightforward the court, the more likely it's going to be protected if you do good planning. These are some of the ways we add. I had mentioned we create actual irrevocable trusts with a substantial ownership, more than 4 or 5%, to trust for kids that cannot be changed, and the trustee votes, or the trustees afforded non-voting rights, but it's real. It looks substantive. You can, when you choose, right? So we're probably going to not choose California. We like the trusts in Nevada a lot. We like the trust in South Dakota a lot. We'll get more into trust in a second. The Nevis, if we go out of the country, so you may want to go out of the country. Typically, if we go out of the country, it's more expensive, and you have a more expensive compliance to go out of the country. But it's extremely protective because the court in the states doesn't have jurisdiction over the trustee or the assets. The statutes, both on the LLC and trust side, are also protective. I had a hand in drafting the LLC statute. We threw every protection in the kitchen sink into this thing. But the real protection is that the asset's offshore, and so is the entity. And if you have a trustee, the trustee is offshore. Offshore manager is not bad either for an LLC. This also, we try to, if we have husband and wife, we try to we own the interest, tenancy by the entirety. So you have to have a claim against both owners before you can even get a charging lien. And then if you have a single individual, you can't do tenancy by the entirety. So what are your options? Well, we can do a domestic or a foreign self-settled trust, which may or may not work, but it's better than holding a single member LLC as an individual. If you're an individual, you get sued, you're a single member LLC, there's a pretty good likelihood you're going to lose that. You're going to lose that entity and the assets inside it. So we often go to a domestic asset protection trust, and we'll segue into that. We've got a lot of sophisticated people on the line. Obviously, you're aware there's revocable, there's irrevocable trusts, there's trusts that just do certain things. There's trusts where we place assets in for somebody else, and only the trustee can decide if assets come out. Those are the most protective. Where we have a distribution in the trust, a lot of people don't understand that, where you already say when she turns 30, she gets the assets. The moment she turns 30, even if there's no distribution, that creditor can take those assets. So you got to be careful with these mandatory distributions. We have people come in, two couple people a month, every month, say, well, I have a trust. What they have is a revocable trust, which is essentially a fancy will, does not protect the assets in any way. Here are your trusts outlined, revocable versus irrevocable, and the asset protection trust. When we refer to asset protection trust, we mean can you create a trust for yourself that's protective? Because you can't do that except in 20 states, which is a lot now. Actually, it started as a couple of states. Here are the states. The law that came from England says if I create a trust for myself, it doesn't, the trust assets are not protected from my creditors. We've had some bizarre advice given to clients from other firms, but that's the deal. If you create it for yourself and it's in Florida, it doesn't protect the assets. You know, if you're not in one of these 20 states, and some of these states have a lot of technical compliance requirements. You also have to comply with that. We like Nevada and South Dakota is not too bad on the technical side. So if you have a single member LLC, maybe we drop it into a self-settled asset protection trust. Have they been successful in protecting the asset involved? Well, when we choose a jurisdiction, we look at that. Have they been successful? What required context do you have to the jurisdiction? If a court in Tennessee says, look, we have this self-settled asset protection trust, but you have to live here, or you have to have some kind of property here, or there has to be, and there's not, you can't use a jurisdiction. You've got to go through the pieces, the requirements, and determine if they work. We've had clients, actually, we do a lot of Nevada self-settled trust, buy property in Nevada, create a connection to Nevada, because it helps a lot with the enforceability. They're somewhat untested, and what we tend to look at is the case derived in bankruptcy or not? Because if it's bankruptcy, the bankruptcy court can use public policy to break through these trusts. They can just kind of ignore, from what I'm seeing, they can kind of ignore the actual underlying protections. In Uber, you had a developer create an Alaska trust, but all the assets, Uber and everybody else, were in Washington State. So you got to be careful with that, especially in bankruptcy. So he ran into problems. And instead of trying to figure out, well, you know, what's protected and what's not, or what do I need to do to augment the protections in place, he goes bankrupt. So he gets the discharge of indebtedness, and it's almost like a quid pro quo. Okay, you've got the discharge. Now we're going to start looking, we're going to take a hard look at these assets. And he had essentially no connection to Alaska. And so they broke through the trust. Not a lot of legal analysis, by the way. They just basically say, well, in light of public policy, we're going to break through the trust. So there's a line of cases from the 80s and 90s that deal with breaking through foreign trusts and bankruptcy. They typically refer to those cases from the New York, New England area. In Mortensen, it was kind of an interesting case. It's kind of funny in some ways, the case. But anyway, it's a mountain guy who created his own self-settled trust. There was a divorce involved. He then got mired with creditors, and essentially there was a claim that he had formed the trust for asset protection purposes to avoid the creditors. And a number of years had already passed. So the actual term to file an asset protection claim had passed in the civil court. I think it was 4 years. So you couldn't claim it. You couldn't go after the transferee and get back the assets. They were protected. That's how it works. If you don't make the claim on fraudulent transfer, the protections go into place. But he filed bankruptcy and extended the statute of limitations on fraudulent transfer to 10 years and lost the assets. It's an absolutely heartbreaking thing. In Trustco, it's a similar issue where you had Delaware asset protection trusts, but when they formed the trust, when the defendant formed the trusts, they notified the potential creditor, which was the bank, Trustco Bank. And what that does is it starts the statute of limitations. So we like Delaware and we like Nevada, and we like notifying when we choose a jurisdiction, then we notify the creditor with a letter, certified letter that typically they don't even, I don't know if they understand it. I mean, we set out what we did and how, more or less how it worked, but I'm not sure they get it. But you have given them notice that you've done this planning, you've made the transfer, and that clips the statute of limitations. Otherwise, it stays open until they know about the transfer. So, you don't even have any litigation at that point. Litigation could come 3 years later or 5 years later or whenever, and then they would have to make a claim for fraudulent transfer on collection after they become a creditor in court. And usually the statute's run. So you keep that in mind, that notice period, and with respect to what jurisdiction you're dealing. In Nevada, for instance, it's only a 2-year statute. These are cases involving compliance with a domestic asset protection trust statute. In other words, some involve financial statements, a statement of solvency, etc. Also, typically they require a trustee in the state, and that trustee has to have certain powers. If you don't comply with this, what happens is when you get into the problem, they take a hard look, through the microscope at how you form the trust, and if you didn't comply, you could be exposed. The combined aspect, which jurisdiction do we use for the trust? Which jurisdiction do we use for the LLC? Well, we might not use the same jurisdiction based on the protection. But for instance, if we have a single individual, we want to use a domestic asset protection trust over the LLC. We want to make absolutely sure that LLC statute says the single member LLC is protected. If nothing else, we can go back to the statute, right? And then if it's someone who has a number of properties, then we do regular planning. We segregate the properties. We don't put the business in with the investment assets, etc. This is an older chart, but it kind of gives you an idea. Well, which jurisdictions are we going to choose? Offshore. We like Nevis a lot because it kind of clicks all the boxes. And you can go through these factors. They are significant with respect to people who actually sue in Nevis. For instance, the fraudulent transfer claim ends. You can't get a charging order after a certain period. The charging order expires. But the key to the foreign trust is you've got the foreign asset in a foreign entity, right? With a foreign trustee with legal title, and the U.S. court doesn't have jurisdiction. Keep in mind, we do have the Full Faith and Credit Act of the United States Constitution in the U.S. So the Full Faith and Credit Act says if I have a judgment in New York, I can enforce it in Florida. The judgment. So I may have been able to get a judgment based upon a weak LLC in Kentucky. I have to know that the Kentucky, we just did a Kentucky, is weak. We get the judgment, we break the LLC, we get to the assets, we have the judgment. Florida has to abide by it. Nevada has to abide by it. That's not true offshore. And here are some typical issues that come up with respect to whatever jurisdiction's chosen. You want to make sure you can choose a protector so that the trustee cannot write checks or move any money without the protector, typically a good friend or family member. You are going to have extra compliance for the foreign trust. And one thing we do mention a lot is, even though the client may want to give up certain powers of distribution to the trustee, the clients really can still manage the assets a lot. They can't move the assets out, but they still make all the investment decisions. And then there's some cases that give us some insight into exactly how foreign trusts are breached. And we talked about Barber, where the court decided to call it a Florida entity. In Sargent, what had happened was the plaintiff got a judgment in Florida, and the court told him, well, you got the judgment, but I'm not going to hold Al-Salah in contempt, so you're just going to have to enforce the judgment in United Arab Emirates. And that was a huge debtor win, but it's been overturned in the Shim case, which was a similar set of circumstance, but it was a Korean asset. The asset was in Korea. Bushell wanted the asset. The court said, well, we're going to send this up to appeal. And it turned out that Bushell won. You can hold Shim in contempt until they bring back, this was like a Korean CD, until they bring that asset back. In Rush, they won, the plaintiff won, because it was a decedent who had a foreign trust, and some assets were in the US, a very wealthy guy. And basically, the decedent had promised, and Rush University Medical Center relied on this promise to fund a wing of the medical center. And I think they had started and had a huge line of credit, and they needed the money. So it was very unfair that the actual inheritance said, no, we're not going to fund that. So they did break through that. Here's some issues with the Full Faith and Credit Act that I had mentioned, which is stronger, which is more convenient. And then you have your standard means of attacking these trusts, which are very similar to the LLCs. Are they real? Is there a third party trustee? Are the assets not totally available to the beneficiary? You know, can your client just at any moment pay his electrical bill with that? You don't want that. You might want a quarterly distribution, but you want a formal request of the trustee. The trustee then issues. You don't want the trustee to come and have to pay a $500 bill, every third day. It really then just looks like the client, and those are just ripe for breaking through. And they can't be a sham. Obviously, you can't fake it. And what we had talked about with Shim is, what happens is the court, and this typically only happens with a bad actor, but it can happen sometimes in a divorce, this type of thing, where the court may hold the beneficiary grantor in contempt until they bring the asset back. You can't say it's impossible because this guy, the founder, created the impossibility in the foreign trust. So that's kind of out the window. But what's happened in most of these cases is the person goes to jail, but the plaintiff either doesn't get the assets, or it's a settlement for pennies on the dollar, even in the bad actor case. And this keys to effectiveness is essentially create a connection to the trust, make the trust real, avoid bankruptcy. And let's take the last 10 minutes and go through some of the tax. When we do these transfers, we keep the estate and gift in mind, because we sometimes can do some significant planning, both domestically and offshore. We currently have the almost $13 million estate and gift tax credit. You can also give away $17,000 a year to, per individual beneficiary without touching the credit. This 13 million is going to go away in 26 unless the law changes. It's a tremendous amount of money, especially if we amalgamate the 26 for husband and wife. And based upon the strategies we have and that are outlined in the code, you can really leverage that to much, much more money. A lot of that money can be gotten out of the estate. It's never taxed again if it goes to trust. there just isn't enough planning going on. We're doing a lot of planning, but really, this is the moment, because this slips back to essentially a $5 million exemption. A lot of this stuff's not going to be available. Offshore, we talk about the complexity of income and estate tax. We're subject to worldwide income tax and estate tax on all assets everywhere if we're US people. If we're a resident, full-time resident, or a citizen. A resident changes, the definition changes on income tax and estate tax. Principally, if you have a green card or you're here for more than half the year on a weighted average of several years, 3 years, you're subject to worldwide income tax. The estate tax, if you're here and you don't intend to stay, and there's evidence to that effect, you're not subject to worldwide estate tax. So you still can buy foreign assets, and those foreign assets can throw off income, foreign income, buy and sell things offshore, unrelated to the US, no tax, no tax. That's why we got to be very careful with respect to transfers into the US offshore, buying US assets without having an offshore entity buy them. There's a whole process that everybody who's investing in the US from abroad should go through. It's a different seminar. It's obviously quite involved, but here's a little flavor. On the income tax side, foreign people, non-resident aliens, you're not taxed on capital gains unless there's real estate involved. That freaks out a lot of people, not taxed on capital gains. There may be a treaty where you may have assets in the US, but your country has entered a treaty with the US, and you might have certain both income and estate tax benefits to that treaty. Sometimes if we have somebody who's abroad and wants to come in, we can use a foreign trust to retain all of those benefits of a foreigner owning foreign assets, which isn't taxed by the US. On the estate tax side, we talked about capital gains. It's the same idea with intangibles. You can give away all your US intangibles, all your stocks and bonds, no tax. But if you die with them, they're taxed. If we have intangibles and we think we're going to keep them in the US, let's get them out of the country. Let's get them owned by something that doesn't die, so that when you go, you're not taxed by the US. That big exemption is $60,000 for non-resident aliens. It's a disaster to die with these assets in the US. This deals with what's a foreign trust, what's not a foreign trust. If a US court cannot bind authority to that trust, or a foreigner manages it, it's a foreign trust. You've got to go through all the compliance, which is great if you utilize it well. If you're not going to utilize it well, or it's unintentionally a foreign trust, kind of a disaster. We're dealing with a ton of those because nobody complies with it. It ends up draining the assets of the trust. It's terrible. Let's avoid foreign trust status if we don't intend to have foreign trust status. With US people doing asset protection planning, in a nutshell, if you have a US beneficiary, which you almost always do, it's considered grantor, which means it's disregarded for income tax purposes. So you're not going to have an income tax issue. You're going to be taxed on those assets offshore in the foreign trust. When you die, if you had removed those assets from your estate, you've got to be very careful, because then it's a deemed sale of those assets. The general rule is when you move it offshore, it's a deemed sale, but if it's grantor, no deemed sale. You just pay taxes if you own the assets directly. When you die, it's a deemed sale if you moved them out of your estate. So typically, well, I shouldn't say typically, but most US people that are using these foreign trusts are not using them to get assets out of the estate directly. If you get the step up in basis, the statute says basically if they're in your estate, you don't pay that deemed sale on them because they're in your estate. So you have to be very careful with that. The same is true if you're offshore coming in. There's a 5-year lag rule where that same process you become subject to. It's kind of complicated, but it's really its own seminar. And then, why I mentioned treaties, the treaties really can play a role with respect to people who domiciled outside the US. If you're, even if you're US, paying US income tax or for whatever reason, and you're domiciled in France, France may actually govern, and you avoid the US connection. It can be very, very helpful. That's kind of wrapping up our 50 minutes. This is some more treaty information on this slide. Treaties are a little tricky because the treaties treat different things differently. In other words, if I say I've got stock in a US company, that's a US based asset. But some countries say, no, it's where the stock certificates are located. So that locality, that situs governs, but they don't agree on situs. It can be a little tricky. And that concludes our presentation. I hope that was helpful in terms of choosing which jurisdiction you want to use on asset protection planning and some of the attacks. If you have any questions, please write them in to Tony. If not, have a great day. We thank you so much for attending.